Welcome back to this second segment of this law session on contract, duress, and undue influence. Just before the last break, I said we would come back and look at the Universe Sentinel. So without much further ado, let's consider what occurred in Universe Tankships and International Transport Workers Federation, subnom, or also called the Universe Sentinel. This is a 1983 case coming out of the House of Lords. Now, the International Transport Workers Federation had blacked a ship, meaning that they decided they were not going to do any work, or they were going to make sure that they adversely affected how it was dealt with. Now, the ship was the Universe Sentinel, and they blacked the ship to prevent it from leaving port. They made several demands in relation to pay and conditions, and also demanded that the ship owners pay a large sum of money to the Seafarers International Welfare Fund. So there's a little bit of economic duress bordering on blackmail happening here. The ship owners agreed in order that the ship could leave port, and then sought to recover the sum paid to the welfare fund. So it was pay our fund, or pay to our union, or your ship will not leave. So they did. The court said that the money had been extracted under economic duress and could be recovered. Now, the House of Lords said that the earlier case law had been wrong to look at coercion of the will so as to vitiate consent. During an analogy with the defense in criminal law, where it is recognized that a defendant acting under duress has the intention to commit the offense but is excused from the crime because they had no choice to submit, that was the route that they went along here. Now, Lord Scarman in the case said the classic case of duress is not the lack of will to submit, but the victim's intentional submission arising from the realization that there is no other practical choice open to him. So really a sort of gun to the head type scenario here. Accordingly, in the case, two elements of duress were identified. The first was compulsion of the will, absence of choice, or illegitimacy of the pressure. Now, on the illegitimacy of the pressure, initially it was thought that the threat must be unlawful. So when we look at Dimskull Shipping, and again it was the Federation, the ITWF, the case is sometimes called the Evia Lock, 1991. We see the ITWF, the Federation, threatening a strike action unless certain demands were met. Now, the cost of strike action would be astronomical for Dimskull, and therefore they agreed to the demands. They later sought to have the agreement set aside as being procured by duress. There was clearly present some degree of coercion of the will and absence of choice. The main question for the court was the legitimacy of the pressure. Now then, at the time that the strike was being threatened, the Evia Lock was in Sweden. The court had to determine whether English law applied or Swedish law applied to the threatened strike action, as under Swedish law, the threatened strike would be lawful, so there would have been no illegitimate pressure. However, under English law, the strike would be unlawful and the threat would be regarded as illegitimate. They said that English law applied and the threat was therefore unlawful and illegitimate. And of course, they didn't have to, of course, they could get out of the contract. The other case that raises this to the fore, of course, is CTN Cash and Carry and Gallagher 1994 case decided in the Court of Appeal, where the defendant sent a consignment of cigarettes to the wrong address. The cigarettes were then stolen. The defendant mistakenly believed that the cigarettes were at the claimant's risk and sent them an invoice. The defendant threatened to withdraw the claimant's credit facility unless the invoice was paid. The claimants needed the credit facilities and so paid the invoice and then sought to reclaim the money on the grounds of economic duress. The court said that the threat to withdraw credit facility was lawful, since under the terms of the credit agreement, credit could be withdrawn at any time. Therefore, as the threat was legitimate, economic duress could not be established. However, obiter in the case, not in that case, my apologies, obiter in a case of the Crown against Attorney General for England and Wales in 2003, Lord Hoffman suggested that there is certainly a different approach. He said the legitimacy of the pressure must be looked at from two viewpoints. He says you examine it from two aspects. The first thing is the nature of the pressure, he said, and then you look at the nature of the demand which the pressure is applied to support. Now, he refers back, of course, for support in Lord Scarman in the Universe Township case. And generally speaking, the threat of any form of unlawful action will be regarded as illegitimate. On the other hand, that fact that the threat is lawful does not necessarily make the pressure legitimate. And this, of course, is credited to Lord Atkins' statement in a case called Thorne and Motor Trade Association. And the remark is that the ordinary blackmailer normally threatens to do what he has a perfect right to do, namely, communicate some compromising conduct to a person whose knowledge is likely to affect the person threatened. What he has to justify is not the threat, but the demand for the money. Now, yes, we're dealing with the law. The devil is in the detail. So when you look at it, the court is saying you have to look at whether the pressure is justified and then look at whether the demand is justified. Because I can threaten you, but when you look at what it is that I'm demanding, and that's where he's saying a blackmailer doesn't have the right to the money, but you can say whatever you like to compromise you because I may know something about you, which is why I am blackmailing you. But that was the analogy drawn there. Well, what happens when you get a finding of duress? Well, since duress operates to deflect the will of the party rather than vitiate consent, the effect of a finding of duress is always to make the contract voidable, not void. And of course, the case for that suggests that is IFR and Federal Trade Spa, which you can look at for the principle. What I want you to imagine now, though, is what if the situation which has occurred to make the claimant's will overborne is not threats which amount to duress, but something a little bit more sinister and more subtle? What I'm speaking, of course, here about is looking at undue influence. What is undue influence? Well, undue influence exists where a contract has been entered into as a result of pressure which falls short of amounting to duress, and the party subject to the pressure may have a cause of action in equity to have the contract set aside on the grounds of undue influence. Now, undue influence operates where there exists a relationship between the parties which has been exploited by one party to gain an unfair advantage. Now, we see that the cases in this area have been varied. It has been where, though, the vast majority, indeed the bulk of the cases in this area tends to be based on situations where you have a bank or a building society seeking to have mortgage payments being made, and on the back of those mortgage payments not being made, to have the property repossessed. But then what you have rearing its head is a spouse in the property saying that because the second mortgage to do with the defaulting spouse, as it were, business, because this second mortgage was taken or borrowed in order to deal with the spouse's business, they still needed somewhere to live. And that's where we've seen the courts have had to deal with this and an extraordinary amount of activity in this regard. Well, from those cases, we've seen that undue influence will be considered from two positions. The first is whether there is actual undue influence, and secondly, where there is presumed undue influence. Now, where a contract is found to be entered into as a result of undue influence, this will render the contract voidable. and of course will enable the person influenced to have the contract set aside as against a party who subjected him to such influence. In addition, in some instances, the party influenced may be able to have a contract set aside as against a party who was not the person inflicting the influence or pressure. So going back to my scenario, what we tended to see was the bank allowing, for example, a husband to take home the documents for the wife to sign, and then we see that the husband wanted to, for example, use the money to go into some business which he knows nothing about. The business falls flat on its face. The bank wants to get the money. The bank was not the person who exerted the influence or pressure, but what we see is the wife in that scenario being able to say that it was they are bringing the action, or they are resisting any action from the bank. Now, looking at the classes of undue influence, there's actual undue influence, class 2A, class 2A, presumed undue influence, and class 2B, presumed undue influence. Now, when we come back from this very short break, we will look at the case which has given us this categorization, and certainly we will see in an expanded format how they actually work in practice.